Welcome to the refresher course for law teachers. Today we are going to be looking at how one can comprehend federalism and what sort of ways, what sort of approaches can we adopt to teach federalism in a more dynamic, in a more updated manner than it is traditionally taught. The goal in this session is not to criticize or critique approaches to teaching federalism, but to explore the different approaches that exist and how they improve or how they contribute to teaching federalism in the classroom. Apart from just looking at these different approaches, we are also going to try and identify the limitations in these approaches and how they can be dealt with better. In traditional teaching of federalism in constitutional law, it is taught by focusing on a few features. For example, Schedule 7, the relationship between states and between the center and the states. It is looked at through key judicial rulings such as S.R. Bommai, and it is looked at through frameworks such as Article 356 and how they impact the center-state relationship. Apart from this, there are some standard discussions that happen around the fact that whether India can be called a federal state, can be called a federal, whether the Indian constitution can be called a federal constitution in the first place because of the heavy center bias. However, because of the S.R. Bommai judgment, it is clear that federalism is a key feature of the constitution. It is part of the basic structure of the constitution and that cannot be changed. Therefore, federalism cannot be restricted to teaching it in the traditional fashion, where we look at the distribution of powers, where we look at legislative competence and we stop at it. Instead, we have to explore and we have to look at something that is a broader underpinning, that provides a broader philosophical explanation of why India's federalism is as it is. Perhaps one of the most important things for us to do in this regard is to understand that federalism takes on a very dynamic meaning in the Indian constitution. It cannot be restricted solely to looking at center-state relations or looking at legislative competence. It has to take on the meaning of what it means, for example, with respect to India's embrace of pluralism and diversity, what it means for different communities who decided to be a part of the Indian Union when they did. Now, this basically means that what we are looking at is not federalism as it exists in other countries, but an Indian federalism. And Indian federalism by its very nature means that it is asymmetric in nature, as scholars have used this term, including Balveer Arora, who we will be discussing briefly. Now, the idea of asymmetric federalism basically means that different entities, different units of the union enjoy different levels of legislative competence and power and autonomy, and there are entities, there are organizations, there are institutions that are sub-regional or sub-state as well. Now, this creates a union that is diverse not only in terms of the communities or the sorts of people who live in, but also diverse in the kind of political arrangements that are made. Therefore, we have to then find different ways of teaching asymmetric federalism in order to be able to better explain to our students what an amazing Indian Union we have created. One of these approaches is to look at the formation of the Indian Union through historical processes. We can of course go all the way back to the pre-modern era and look at medieval or even pre-medieval arrangements between the Union and different entities of the Union. However, we can and we must restrict ourselves as constitutional professors to looking at things that happened after the constitution or around the process of the constitutional formation. One of these things is to look at discussions in the Constituent Assembly on how members viewed the relationship between the provinces and the state, and how representatives of different communities looked at the relationship between the state and themselves. One of these examples that I would recommend is of course Jaipal Singh Munda, who was a leader of the Adivasi community from Jharkhand, and he made amazing interventions in terms of how communities, his own community, looked at the community's relationship with the rest of the country. We can also look at different historical processes, such as how certain princely states came into being and how they came to be a part of the Indian Union. Of course, we could look at Jammu and Kashmir and Hyderabad as contrasting instances. However, there were hundreds of smaller princely states that also came to be a part of the Indian Union. It would be interesting to explore their exchanges, their demands at the time of accession, and the sort of instrument that created, or the instrument that was signed after the instrument of accession, which was usually referred to as instruments of merger. These instruments clearly denote a diversity in terms of how each of these states and its peoples came to be a part of the Indian Union. Another way in which we can approach the question of historical processes is by looking at linguistic states and how they came to be formed. They came to be formed on the back of massive movements in various parts of the country, especially Andhra Pradesh and Gujarat were instances where the movement for a separate state was led on the basis of language. However, we also notice in these historical processes, in the Constituent Assembly, there was a large debate on the uniformity pertaining to language, whether we should have an official language. And as we know, these discussions would have a massive impact on how linguistic movements and subnational movements would engage with the Indian Union. Another way in which historical processes can be incorporated in constitutional law and federalism is by using the framework of continuity and change, which is to say what continued from, say, the Government of India Act, and what changes did we make. For example, what was continuous between various regimes at the center who used Article 356, and what change did we see recently in its application. We can also engage these historical processes of continuity and change by looking at secessionist movements in different parts of the country and how the Indian Union responded to it. A contrast between how one saw the secessionist movement in Tamil Nadu and Nagaland would provide our students with insights that constitutional scholars necessarily require in order to understand things better. We can also look at subnational movements and their articulation and how they related to the Indian Constitution. One example of this is provided by Sanjeev Barwa's account of the Assamese nationalist movement, subnational movement, which he regarded as something that was assertive on identity but within the general Indian framework. Now, moving on, one last thing that this historical processes of continuity and change allow us to do is to look at how backwardness and discrimination and regional disparity get reflected in constitutional discourses. Historical processes allow us to trace certain provisions to a socio-political movement in history or a socio-political moment in history and understand it better. But it has limitations. It focuses on exceptions, not the rules, and it may not provide material that is solely engaging to lawyers who are seeking to understand provisions and their interpretation better. Another approach that we could possibly explore is the comparative approach. This is often used even in judicial discussions on federalism. For example, there is a lot of jurisprudence that is imported from Australia because it is also a country that has the equivalent of Schedule 7 with a concurrent list and a union and a state list. We have very frequently looked and contrasted ourselves from the United States, which is a strong federal state, and allegedly we are a weak federal state. However, one thing that I would like to point out here is writings from Canada have started exploring the idea of federalism better. Samuel El Selva looks at federalism as a way of life and how fraternity can inform it better. For El Selva, the main point is that federalism is seen as a constitutional arrangement or as something that is politically expedient, but not by itself as a unique or an essential feature of the constitutional framework. El Selva looks at the tension between universalism and particularism very differently. For him, the point of universalism is that when it goes to an extreme, it results in assimilationist tendencies, and when particularism gets to an extreme, it results in focusing on the individual as the sole issue, and community rights or group rights are discarded. This, however, is not a problem for us. As Devesh Kapoor writes in seminar, federalism has helped create multiple overlapping identities that have kept the nation together rather than pulling it apart. Indeed, the nation building project has been undermined whenever federalism has been under stress, not when it has flourished. Now, we see that this tension between universalism on one end and particularism on the other is not a problem for India, because we have embraced diversity as something that strengthens the Indian identity and not as a problem that has to be solved. However, El Salva says that fraternity as a way of life, as something that can be a value, can be useful in mediating the tension between the universal and the particular, and it allows for multiple identities to exist without a contradiction coming in the way. Now we move on to a broader, more specific focus on asymmetric, a broader look at asymmetric federalism and how it can reflect on constitutional arrangements that we have made. Balveer Arora says that federalism, although may not be focused on specific provisions, you see that it has quote unquote superimposed itself on parliamentary democracy. Asymmetric federalism, Balveer Arora terms asymmetric federalism as accommodative constitutional engineering that helps in dispute resolution and resolving claims to regional disparity. Pritam Barwa makes a significant intervention when he sees asymmetric federalism as mediating the tension between self-rule and equal representation. Self-rule denotes certain communitarian engagement with the rest of the union as something that concedes to autonomy, while equal representation reflects the principle that one person has one value. This gets reflected in the idea of Lok Sabha, where each person's vote results in a directly elected representative, whereas in the Rajya Sabha it represents proportion of people represented in each state. Barwa focuses on autonomous district councils as the problem statement, and he says that federalism can only help when there is a territoriality of identity. This territoriality of identity, when it comes to autonomous district councils, has incentivized segregation and has encouraged monolithic regional entities. This can also encourage xenophobic ethnic subnational movements, and we must be wary of such an approach while it is helpful. Lastly, we are going to explore Ashutosh Varshney's writing on federalism. He asks a very simple question, which is, how has federalism worked in India? Now, for Varshney, the question we ask is not whether there is a strong center or weak center in India's case, but to understand federalism by understanding what kind of nation state is India. What kind of state is India? Is it a state that is seeking uniformity? Definitely not. Is it a state that is seeking to manage multiculturalism? Doubtful. What it is actually looking at is embracing pluralism and how this pluralism can be reflected in different constitutional arrangements that we have. One interesting analysis that Ashutosh Varshney makes that may be useful for us as constitutional scholars is to see that there are certain identities around which mobilization is permitted within asymmetric federalism. These two identities are language and tribe. On the basis of language, we have linguistic states, and that allowed for strengthening of democracy, as Devesh Kapoor put it. Similarly, the tribe as an organizing principle is also not difficult, since we have schedule 5 and 6. This for Ashutosh is generally based on the idea that they are territorial in nature and non-threatening. In contrast, he notices that when religion is used as the organizing principle for communities, it becomes unacceptable. He gives the example of Punjab and how consequent violence was used in order to quell the separate Punjab movement. These approaches allow us to look at specific provisions and interpret them better. However, none of these approaches are comprehensive by themselves. They do not explore or allow for understanding the diversity of political arrangements in India. However, each approach allows us to explore a different component of the Constitution and to look at existing provisions through the federal principle. For example, in traditional federal studies in India, we rarely look at the question of subnationalism or sub-regional identity, whereas political theorists have been exploring this within the framework of federalism. By looking at these different constitutional arrangements, we strengthen our study of federalism and not weaken it. We cannot look at them as exceptions to the general rule of a state. We have to look at them as part and parcel of how India is structured and how India is organized on the federal principle. Thank you.